Good morning, this is your Kelso Report for Thursday, July 19th. I'm your host, Clark Kelso. Glad to have you with us. We begin with a case involving discovery sanctions. During the military operation in Iraq and Afghanistan, the United States established an air bridge to deliver supplies through war zones to U.S. posts in Baghdad and Kabul. The United States contracted with private airlines to deliver supplies to those posts, and it provided hazard pay for the pilots and crew members of those airlines. Well, a former pilot for Vision Airlines sued on behalf of himself and a class of other pilots and flight crew to recover the hazard pay which allegedly Vision had never paid. After nearly 2 years of discovery disputes between Vision and the class, the district court sanctioned Vision by striking its answer, entered default judgment against Vision, and held a jury trial just to determine damages. The district court found that the defendant had intentionally delayed production of documents, misrepresented its current and past production both to the court and the plaintiffs, and otherwise engaged in bad faith conduct. The defendant here did not even attempt to contest those findings on appeal, arguing only that the district court should have employed a less drastic sanction. Well, the Ninth Circuit was not at all sympathetic. And, to add insult to injury, the panel recommended that the district court in Nevada report defense counsel to the Nevada State Bar for possible disbarment or other sanction. Not a good day for defense counsel. Need to take those discovery disputes a little more seriously. Next, we have a case involving revenue and taxation. 20 years ago, the plaintiff filed a qui tam action under the False Claims Act, alleging Medicare fraud by a hospital management company and several related entities. After the United States intervened, it settled the claim against one of the largest related entities in 2003 for a whopping $631 million. The plaintiff received 16% of that settlement as his relator's share. Nice work if you can get it. The plaintiff originally filed his 2003 income tax return listing the relator's share as ordinary income. He later filed an amended return characterizing it as a capital gain and sought a refund of about $5 million. The IRS denied the refund and he sued. Well, the Ninth Circuit agreed with the IRS that the relator's share was ordinary income and not a capital gain. This is a simple question of statutory interpretation. Section 1222 of the Internal Revenue Code defines capital gain as, quote, gain from the sale or exchange of a capital asset, close quote. It was clear to the Ninth Circuit that there was not a sale or exchange involved in the award to the relator. Instead, as the United States Supreme Court has described it, the payment was simply the bounty the relator receives if the qui tam suit is successful. Like other awards and bounties, the payment is treated as ordinary income. Next, we have a habeas corpus case for the Ninth Circuit, a split decision. The petitioner in Running Eagle v. Ryan and his cousin were convicted of murdering a husband and wife after they pursued them into their home in the early morning of December 6, 1987. The state trial court imposed a sentence of death upon the petitioner, but not upon his cousin. The petitioner's direct and collateral appeals were rejected by the state courts, and his federal habeas petition was denied by the district court. Now, from the time of trial, defense counsel sought what they believed were statements made by the cousin's cellmate to the effect that the cousin did the stabbing and that the petitioner did not actually commit the murders. It was undisputed that state investigators had indeed interviewed the cellmate 5 times. Nevertheless, the state courts refused to order the state to turn over any file containing such statements if they existed, since the courts did not believe the disclosure of such statements would probably have changed the jury's judgment. In particular, while disclosure might have led a jury to impose the death penalty on the cousin, the courts believed the jury would have still imposed the death penalty on the petitioner. A majority of the Ninth Circuit concluded that this explanation adequately satisfied the deferential standards of review appropriate for habeas. In dissent, Judge Pragerson thought they had not adequately explained what happened here and that they had committed a clear legal error in evaluating the likelihood of a different judgment. We'll see if this one goes in bank. Next, we turn to legal malpractice and the one-year limitations period. In Crucier v. Chavos, the 4th District affirmed a statute of limitations defense on demurrer to a complaint alleging legal malpractice. As I'm sure you all recall, according to CCP Section 360.6, in an action for legal malpractice, there's a one-year limitations period that begins when the plaintiff discovers, or through the use of reasonable diligence should have discovered, the facts constituting the wrongful act or omission, or 4 years from the date of the wrongful act or omission, whichever occurs first. Except the running of the statute is tolled until the plaintiff suffers actual injury, and so long as the attorney continues to represent the plaintiff regarding the same subject matter. Now, in Crucier, the attorney had secured a $1 million default judgment for his client in 2006, but then failed to take any appropriate steps between 2006 and 2008 to try to enforce the judgment. By the time he tried to enforce the judgment in 2008, it became clear that the defendant had taken steps to try to remove and hide the assets from enforcement. In June 2008, this led the plaintiff to secure new counsel, who very quickly discovered problems with enforcement. The legal malpractice action was not filed until August of 2009. Well, given this set of allegations, the 4th District concluded the demurrer was properly granted. Plaintiff knew no later than June 2008, when he substituted counsel, of the first lawyer's failure to enforce the default judgment. And it was also clear by June 2008 that the failure had led to actual injury to the plaintiff. So plaintiff had 1 year from June 2008 to file the legal malpractice action, but failed to make that filing until August 2009, more than 1 year later. Seems to me that substitute counsel has some explaining to do. Next, an arbitration case in Nelson v. Legacy Partners Residential. The 1st District enforced an arbitration provision in an employment contract, rejecting the employee's argument that the provision was unconscionable, and concluding that the arbitration clause did not authorize class arbitration, since the provision expressly referred to arbitration of claims between the named employee and the employer, thereby impliedly limiting the provision to individual claims. As a result, the employee will have to litigate her allegations of multiple violations of the Labor Code in an arbitration context and without the benefit of class allegations. This is the sort of case where we sometimes have seen California courts bend over backwards to strike down an arbitration provision, frankly, contrary to the rather clear guidance from the United States Supreme Court. So it is good to see the 1st District correctly enforce the arbitration agreement in this case. Finally, a case involving juvenile law in In Re DS. The 4th District concluded that the juvenile court incorrectly rejected a natural mother's petition to vacate the court's prior order, declaring a stepmother to be the presumed mother of the natural mother's 2 children. At each child's birth, the natural mother and the children's father executed a voluntary declaration of paternity. The natural mother cared for the children for several years until 2004, when the father was granted sole legal and physical custody. The natural mother actually stopped visiting and contacting the children after May of 2007. The father's wife raised the children and held them out as her own. And at a dependency proceeding in 2011, the juvenile court granted the stepmother's request for status as the children's presumed mother. But a short time later, the natural mother reappeared in the proceedings and filed a motion to vacate, which the court denied. The 4th District easily reversed. Under the applicable statutes, the natural mother's status was established by proof of her having given birth to the children, and none of the rebuttable presumptions of paternity provided for in Family Code Section 7611 applied to this case. So the stepmother's petition should have been denied. As the 4th District explained, when a natural mother has first assumed and later appears to have abandoned her parental rights and responsibilities to her child, the appropriate mechanism for a step-parent to gain parental rights is through a step-parent adoption proceeding, not by trying to make a maternity claim through Section 7612. And that's it for today's Kelso Report. Have a great day in the law.